Hello and welcome to the latest episode of Immigration Unpacked. I'm Natalie Loder and I'm a partner in the immigration team at Bindmans. I'm really pleased today to be joined by our head of immigration, Tanya Goldfarb, and our colleague from our employment department, Roshan Dykes. We are going to talk to you today about changes that have come in to the guidance for organisations that hold sponsor licenses because there is a new requirement for them to provide their workers with information about their employment rights. So, Tanya, would you just explain a little bit about what the new obligation on sponsor license holders is and how does that impact their governance of their immigration compliance?
Absolutely. So, firstly, I should note that this was a slight sneak attack by the Home Office in terms of the changes that were announced because they weren't particularly announced. They just suddenly said, "Oh, we've updated the guidance. You need to go, and all sponsors now need to go and look at it." There weren't any real headlines, but the main takeaway from the changes that were announced at the beginning of March are that sponsors now have an even greater rigorous duty to maintain their record keeping obligations and specifically to ensure that sponsored workers are notified of their employment rights. And the requirement to notify them of their employment rights means that they must be in writing, recorded, and are pretty wide ranging. Roshan, I think, is going to talk more specifically about that, but this is really a sign of the times in terms of what the government is requiring sponsors to be responsible for and to ensure that the onus is shifted onto those that participate in the sponsorship management system, i.e., holding a sponsor license.
Mm.
And I should note that they have also changed the wording of what it means to hold a sponsor license. It used to be that it was considered sort of a participation in a system. Now it's membership, and that the onus is very much on a sponsor to ensure that they adhere to the strict terms of said membership scheme.
That's right. It's like being in a regulatory environment, isn't it? So
Indeed.
so it's a sponsorship compliance where perhaps in the past some organizations might have seen it as a one-off administrative process. It's now actually must form part of your general governance, and to make sure that if you are a sponsor license holder, you are meeting your sponsor obligations and duties, and you accept that you are in a regulatory environment with the Home Office and you have these duties in order to maintain your license.
Absolutely. The Home Office has always required sponsors to regularly check into their licenses by logging into what's called the sponsor management system. It's always been understood that they lightly monitor that. Now there is a requirement for a level one user to log into the sponsorship management system at least once a month, check the message board, check if there are any other updates, etc. And the sort of the message that sponsors should be taking is that the Home Office is going to be checking if
Mm.
sponsors are checking into their sponsor licenses, that they're having a look around it, they're making sure that their sponsor notes are up to date, that they've
Mm.
complied with their reporting duties, etc. It's very much it's very much moved from this is in joint enterprise is not really the right
Mhm.
word, but it's a partnership to this is something that the government runs, and we are now, as you say, we are now going to regulate you
Yes.
moving forward.
Yeah, and I think perhaps in the past there was an idea that sponsorship was self-regulating. So sponsors were given a license and they were told that they're being put in a position of trust. And within that trust environment, they have to comply with the rules. But now what we're seeing, and previously it would be that the only way the Home Office would be able to investigate what sponsors were doing would be through an audit, so an in-person audit at their offices, looking at their HR systems, looking at their HR files, and looking for breaches of their sponsorship duties in
Hmm.
that way. Now, because of data sharing agreements with other government organisations such as HMRC, the Home Office licensing team have much greater access to information than they ever have had before. And they are able to see from, that HMRC data where there could be concerns about underpayments to workers and where
Hmm.
those underpayments, may impact the welfare of that worker. And so, they're sort of the uptick in their investigatory activities is there, I think, to make sure that workers aren't being exploited or they aren't being put in positions where, they're not being paid enough to maintain and accommodate themselves in the UK. But the impact of, that very fuzzy end of immigration where, bad things are happening just
Yes.
has a knock-on effect
Hmm.
to sponsors who are actually just trying their best and doing their best by their workers, but it does place them under more rigorous obligations and makes them subject to investigation as well by the Home Office.
Yes, and I think, and we'll move on to what this means in terms of employment impacts, employment law impacts in just a second. But what I think sponsors now should have an understanding of is that it's not a partnership anymore, unfortunately. And the implication is that actually people are doing things either badly or incorrectly or deliberately sort of deliberately willfully misleading. And the presumption that employers and sponsors are going to actually be using the system properly, I think has fallen away. And sort of the presumption of innocence, let's say, which is supposed to be the underpinning of almost all legal legislative processes and landscapes, this is showing to us that actually, I think the Home Office is now just quite suspicious of everything
Mhm.
that and anybody that comes into contact with the system, and compliance action can now occur under any, it seems, under any set of circumstances.
Yeah.
Whereas you mentioned before, there would be an investigation and there would be maybe an interview or an audit, or there would be an assessment of the systems. Now, the presumption is that if there is a slight breach, suspension or revocation could even be automatic. There doesn't need
Mm,
to be an investigation. There doesn't need to be, they're not interested in whether an employer or a sponsor can say, well, actually, here's all the paperwork, here's all the documents. It's going to be in reverse. And that puts people, without being alarmist, on the back foot, and it shouldn't be. This the sponsorship is a very positive force within the immigration landscape, within the British
mm,
economy, within industry as a
precisely.
whole.
So
Yeah.
do we think there is going to be a decrease in sponsor license applications as a result of this? Because there's quite a lot of risks now for employers to take on.
I don't think that there's going to be a decrease in the number of applications, because I think the need for
Yeah.
employers to have diverse workforces and expertise and knowledge from all corners of the globe will be ongoing. But what I think we'll see is an ongoing increase in the number of revocations. Last year, the Home Office suspended and revoked a record number of licenses, like since records began. And that's a record that they're very interested in being very public about. The bottom line is reputable, decent sponsors who are adhering to the guiding principles of sponsorship, genuine roles, the right salaries, ensuring that their record keeping is up to date, should have nothing to fear. It's this is a sledgehammer to crack a nut scenario, because there are rogue sponsors and employers out there, but it's everybody is being tarred with the effective same brush.
Mm,
It's a broad brush for a niche problem.
yeah. So against that
So
background,
against that upbeat
we are
moment,
depressingly looking at increased obligations for sponsors. And so one thing they've been asked to do in the latest reiteration of the sponsor guidance is to make sure they've got records that they have provided their workforce, so their workers, their sponsored workers, with information about their employment rights.
Yeah.
So as I understand, this is an obligation for sponsor license holders rather than an obligation under employment law.
Yes, I mean there are limited obligations under law to provide workers with information on their rights. This goes far beyond that. I mean, under UK employment law currently, because we are seeing changes come in with the new Employment Rights Act 2025, employers have to provide workers with a Section 1 statement. So that's a written statement of particulars which is really just the basic terms of employment, such as remuneration, notice period. And then really it's just sector specific. So in certain sectors, there should be whistleblowing policies,
Right.
and things like that. But this goes far beyond that. So I do think it's quite onerous for employers to have to fulfill these requirements. But it's not to say it can't be done through policies and a staff handbook, for example, rather than training, which I know the Home Office suggests. But I think for smaller employers, it really would be quite onerous to have to provide training on all these different employment rights.
Sorry, I was going to ask if there are specific elements of employment
Yeah.
law that have to be included.
Sorry, do you mean in terms of policies?
In terms of the changes that the Home Office introduced, that they point, do they not, to
Yeah.
certain facets of an employment contract or employment legislation that
No,
sponsors have are required are
they're, well,
required,
they're not giving that specific detail. They've provided a non-exhaustive list and
right?
not referenced the relevant legislation, really. I mean, they mentioned the Equality Act, your duties under the Equality Act, but it's quite vague. I mean,
Hmm.
there are a lot of different um, rights and potential claims that come out of the Equality Act. The guidance really isn't thorough enough, I think. And the fact it's a non-exhaustive list will have employers guessing, well, what other rights do I need to inform my workers of?
Yeah. So I think I'll just read out the list that the Home Office
Yeah.
suggests. So the Home Office suggests that you provide details of entitlement to national minimum wage, compliance with the working time regulations, pension auto-enrollment and opt-outs, entitlement to statutory leave and pay, health and safety, trade union membership, your duties under the Equality Act, and how to raise grievances. So
Yeah.
perhaps, Roshan, we could, I know there's a lot to cover, but perhaps we
Yeah.
might just touch upon each one of these
Yeah.
and think about, what type of information would
Yeah.
employers be expected to provide to their workers in relation to each of these topics. So if we
Yeah.
start with national minimum wage compliance, sorry,
Yeah.
and compliance with the working time regulations.
I mean, this is a slightly strange one because again, employers don't generally have to inform their workers of their obligations to pay national minimum wage and adhere to working time regulations, but it's assumed to be common knowledge, and they have those legal obligations to comply with the relevant legislation. So again, the Home Office is going above and beyond here, or expecting employers to go above and beyond. So I mean, I would recommend that a staff handbook just confirms that the company or organization
Right.
complies with that legislation and maybe has a link to the information on the government
Mm.
website. Because in terms of minimum
Hmm.
wage, that changes annually. And then obviously contracts should have an opt-out clause, or there should ideally be a separate agreement for opting out of the 48-hour weekly
Mm.
limit.
Yeah. Okay. And then what about pension auto-enrollment
So employment contracts should confirm pension arrangements for employees or workers.
and opt-outs?
So yes, they should confirm the right to opt out, and then they should also refer to a policy or handbook that contains further information about the scheme.
So usually we'd see it in the contract, and
Yes.
then there would be some further information in a company handbook.
Yes. And I mean, that's an example of something that should be in the Section 1 statement anyway. So employers should be including that clause in their contracts anyway.
Okay, all right.
Yeah.
So that's where we would then expect to see it. Right. What about entitlement to statutory leave and pay?
So those should be in the contract, certainly in terms of a holiday clause, so holiday entitlement. Now, with regards to other statutory paid leave, this is where employment status is important because employees are entitled to certain forms of leave, whereas workers aren't. And
Mhm.
I am conscious the Home Office doesn't really distinguish between the two employment statuses. So I think employers will need to get advice on that,
Mm.
or may need to get advice on that because they don't want to be conferring employee rights on workers or getting or being confused about that within their policies or contracts.
Yeah, because there's certainly instances where a sponsored worker, I mean, I think for the most part, they would be a direct employee or they would be an employee of the sponsoring organization.
Yeah,
But there are circumstances where they might be
Mm.
another type of organization. So, for instance, under the creative worker route, Tanya, you might
Yes.
have an agency
yeah,
that is the sponsor, but the actual worker is going out to work for, say, a production company or something like that, right? And then we could also have an instance where you're a partner in an LLP, in a law firm or an accountancy firm or an architect's firm, and technically you're self-employed
yeah,
as an LLP member, but
Yep.
those roles are capable of sponsorship in the
Hmm.
same way as if you would be an employee.
yeah,
So we do have different types of
yeah,
worker.
yeah.
And what we want to make sure when we're providing this information, or what sponsors would want to make sure, is that they're not conferring rights where they don't mean to confer rights. Yeah.
Exactly, exactly. Or to mislead their workers
Mm,
because, for example, paid paternity leave is available to employees, but not certain forms of workers. So,
sure.
yeah.
Right.
Okay, health and safety.
Health and safety. So in UK employment law currently, it's an obligation for employers employing five or more people to have a health and safety policy. So again, this is the Home Office going above and beyond. So we would just recommend there's a health and safety policy.
Mm. And I think often, with, for instance, with the pension opt-outs or pension
Yeah,
auto enrollments, health and safety,
yeah,
they're often standalone policies which employees are asked to sign when they join.
yes,
So
yeah,
that's one way that the record could be kept, where
yeah,
we can show what's been provided and also when it was provided.
yeah. I mean, I would just recommend a staff handbook that contains all these policies and that employers ask their workers to confirm they've received it and
Mm.
even read it, and that can be kept on record then.
What would be the normal sort of time period then? So say I'm joining a company day one and they give me the employment handbook. Would you usually sort of give a week or so to
I
return a
think,
signed
yeah,
statement to say you've read it?
week, 10 days, 2 weeks would be
Mm.
fine. Yeah.
What about duties under the Equality Act 2010?
I mean, this is really wide ranging because workers and employees are protected from discrimination, and there are different legal definitions of discrimination. We have direct discrimination, indirect discrimination, harassment, victimization. So those are all specific legal claims and forms of discrimination under the Equality Act. And that must be on the basis of protected characteristics. So religion, race,
Mm.
sexuality, sex, for example. So really the safest way is that employers have a diversity and inclusion, equality and inclusion policy
Mm.
that just confirms workers' rights under the Equality Act and actually even contains a definition of each of those forms of discrimination. And in fact, this is one area where it's recommended that training is provided, certainly to managers.
Right.
So then also employers are protecting themselves in the event of a claim
Hmm.
and can show that they have taken reasonable steps to preventing discrimination.
Right. That's really useful. I think the other thing was trade union membership.
So this actually reflects in part a change that's being brought in by the Employment Rights Act 2025, which will require from October this year that employers provide a statement alongside the Section 1 statement. So usually that's an employment contract. So at that point, employers should provide a written statement to their workers confirming their right to join a trade union.
Mm.
Now, regulations that will bring into force that change will specify what that information should actually be. So
Okay.
there may be further details which will be in line with this Home Office requirement. So it's not just the right to join a trade
Mm.
union, but the rights of trade union representatives, for example, as well.
So this is
Yeah.
something that sponsors will need to monitor on an ongoing basis, and it's at the moment
Yes.
the situation is watch this space because we're waiting for further announcements.
Yes, but again, for employers to comply with this Home Office requirement, they should just begin doing this
Mm.
anyway, I would say.
And how to rave grievances.
Yes, so the employment contract should either attach the disciplinary and grievance procedures. It's not just grievances, actually. It's also workers can be subject to a disciplinary procedure, but they have the right to expect a clear and formal process to have a fair process.
Mm.
So those should be referenced in the employment contract. They can be attached to it, or the contract can refer to the policy that contains the procedures.
Okay.
And those should also confirm their right to be accompanied to formal meetings or hearings.
And again, you would expect to see that in the contract then, and then also in the employment handbook.
Yes.
Yeah.
Yeah.
And do you have any further recommendations? So the Home Office list was non-exhaustive.
Yeah.
Can you identify any key rights which should be
Yes.
included that the Home Office haven't listed in their guidance?
So I would say whistleblower protection, because that's a key right that workers have under the Employment Rights Act, which was amended by the Public Interest Disclosure Act. So I would say employers should have a whistleblowing policy, which
Mm.
confirms their right to raise protected disclosures, that they shouldn't be subjected to detriment for raising those disclosures. And actually, certain employers have to have a whistleblowing policy. So public bodies, for example, and also I think FCA regulated employers. Also, it should be noted that the Employment Rights Act 2025 is strengthening actually expanding protected disclosures to sexual harassment as well. So again, because that change is coming in, I just think it's important employers have a whistleblowing policy.
Mm.
And
Absolutely.
sexual harassment as well. So the duty to take all reasonable steps is being expanded to, sorry, currently is
You
to
mean
take
to
reasonable
prevent?
steps.
Yeah.
Yeah, to prevent. It's being
Yeah.
expanded to all reasonable steps
Right.
by the Employment Rights
Ah,
Act. So I think it's important again for employers to have a sexual harassment policy, a
Mhm.
standalone policy.
And perhaps this is another area where training is important.
I think so.
Yeah.
Yes, definitely. Yeah.
Yeah.
and
Oh.
is it a requirement under any employment legislation that a copy of said contract has to be on an individual's HR or personnel file, or is it just having it be able to be accessed, say, on a firm's any company's intranet? Is that sufficient?
Requirements at all. It's just to provide the Section 1 written statement in particular.
Right.
So we insert, soon after or at the beginning of employment. So there are no obligations about keeping records of that.
But that's in sort of contrast to the requirement of sponsors to keep
Yeah.
records and to undertake
Yeah.
record keeping duties and responsibilities. So it's interesting that yet again the employment law requirements are being foisted upon sponsors but they're at a sort of almost at a dichotomy with each other, and so
Yeah.
they're going to
Mm.
bump up against each other.
A lot of this is best practice for employers anyway.
Right.
So yeah, I think and of course because we have the Employment Rights Act, which has just come in, the 2025 Act, this sort of aligns with the increasing protections for workers. But I
Yeah.
do worry it's quite an onerous requirement for certainly
Hmm.
smaller
Mm.
employers, and
Hmm.
it's quite a big change for them to have to implement. Yeah,
And not all
Yeah.
small firms will have a company handbook, for instance.
exactly.
So,
No.
they might have some standalone policies,
Yeah,
for instance, on health and safety or the pension,
yeah,
auto enrollment, but they wouldn't necessarily, as a matter of rote, have a whistleblowing policy or
no,
have, information about trade unions
No.
available. Yeah.
exactly.
Yeah. So
Yeah,
I suppose the important takeaway is that all sponsors should be considering having a company handbook if they
yeah,
don't have one already.
Hmm.
Those that already do have one must ensure that they're kept up to date and
yeah,
kept somewhere that employees are able to access it. So, for instance, on an intranet
yes,
or in an office readily available for someone to look at should they want to. And then the other thing is that from I think the guidance was updated on the 5th of March 2026. So any employee starting from that date, the sponsors should have a record that they have provided them with their employment rights, information about their employment
yeah.
rights, and that they've got a record of what they provided and the date they provided it.
Yeah, and I'd say employment contracts need to be reviewed as well.
Yeah. So perhaps
Yeah,
it's
Right.
worth having a joint employment immigration audit to
yes.
try to make sure that you are meeting your sponsor obligations within this regulatory environment that has evolved for sponsor license holders. Roshan, you've been really enlightening as always. Thank you so
Good.
much for
Thank you.
imparting us with your employment knowledge, and Tanya as well. Thank you so much for your insights into the landscape around sponsor licensing, which has certainly evolved over time, but very very rapidly over the last I'd say 24 months. We've really seen a massive shift
Hmm.
in the way the Home Office approaches compliance breaches. It's been fascinating to talk to you both. Thanks so much. This has been Immigration Unpacked, and we look forward to seeing you in our next episode.
Thank you.
Thank you.